everyone, it's Jesse Green here. Welcome to tonight's training with John Wilson. We'll get underway in just a little moment. Before we do, however, I just want to do a quick audio visual check. We've got people streaming into the webinar now, and I just wanted to check that you can hear me. You can see John's screen there, which should be a slide there. Thanks, Jacob. You're a champ. That's awesome. So it's good to see so many people here. We'll get started shortly. Hey, Mary. Hi, Genevieve. Kingswood Dental. Great. Good to see you guys. Hey, Sally. Thank you for checking in. Appreciate all of that. So we're going to get started in about a minute or two. And the way the format's going to go tonight is, firstly, I'll start with a bit of an introduction. But the way the format will be is that John's got some material that he's going to go through, which is incredibly relevant to not just the time frame that we're in now with the coronavirus or COVID-19 pandemic and all that is involved with JobKeeper and so on and so forth, but we're also going to be talking about having the employment structures set up right moving forward in a post-COVID world. And this is going to be really important, in my view, to make sure that your business, your practice is positioned well to be able to be nimble, to be able to respond to market conditions that will invariably change over time. So John's going to go through his material. We're going to do a bit of Q&A at the end of that. I've got some questions that have been submitted earlier. And so for those people who would like to ask questions, my role is going to be to collate them. And then if you can type them into the chat box rather than the Q&A section, that would be great. The chat box as well will be able to really collate all of that, and I'll ask those questions. What we'll probably do though is let John go through all his material uninterrupted so he can maintain his train of thought, and then we'll ask questions at the end if that's okay with you, John. Okay, just got to unmute yourself, mate. I can do that for you. There you go.
That's all very good, Jess.
All right, lovely. All right, so I think it is officially 5 o'clock, and I'm just going to make sure I don't make the rookie error. The rookie error is to have your phone not on airplane mode. So I'll just make sure that's on airplane mode, so we're good to go. All right, so ladies and gents, welcome to tonight's presentation from John Wilson. John is a specialist employment lawyer, and he has been my go-to lawyer now for, I think, John, I was looking at this the other night. My oldest daughter is 16, and I think we first engaged you on and around that time that she was born. So it's a long time we've been working together. So John is my trusted advisor. I've worked with him, as I said, for 16 years now. Specialist employment lawyer. I'm almost embarrassed to say that I could recite the business's telephone number by heart. And I don't know if that's a good thing or a bad thing, but invariably John's been of enormous help to me. And I know that the material we're going to cover tonight is going to be incredibly useful, incredibly valuable. And I'm going to encourage everyone to take some great notes, to please type your questions into the chat box, and we'll do our best to get through them all. And we'll go from there. So John, thank you so much for taking the time out of your evening. I know you're working remotely at the moment in this pandemic. I can see in the reflection a beautiful palm tree behind you, and I know that you're up in the coast. So thanks so much for taking the time away to come and hang with us, mate. And I've been looking forward to this training in particular for a very long time. So thank you for making it happen.
Thank you very much, Jesse, and welcome to everyone from Lennox Head on the far north coast of New South Wales, where I am doing my isolation from Canberra. Now, the purpose of my presentation tonight will be to take you through some most significant developments that the federal government has implemented in the last fortnight or so to do with employment-related responses to the pandemic, the major one being the JobKeeper payment system, which all of you would have heard quite a lot about, I imagine. I'll go through some of that. And also associated rules that the federal government has implemented, and as recently as the 20th, that is on Monday, was the last raft of amendments to try and provide for a degree of flexibility in the arrangements you can implement to deal with your particular circumstances that have arisen through the COVID-19 pandemic, and that bypass, as it were, the strictures that normal workplace and employment laws impose. Now, if I move on to the next slide, this essentially summarises what I've just said, that there have been recent provision of the JobKeeper payment scheme that has resulted in associated changes to the Fair Work Act that commenced on 9 April this month and have further been amended right through to this Monday. I'll talk about eligibility for both JobKeeper and also to access those flexibility changes to the Fair Work Act. And at the end, I am happy to take any questions that you have through Jesse. I acknowledge and have come prepared to answer questions that go beyond the particular JobKeeper and related changes to the Fair Work Act that I'll run through now. And so please feel free to ask me any employment law question that you consider relevant. Now, the background to the JobKeeper payments and what are known as JobKeeper directions that are now in the Fair Work Act is that prior to or immediately prior to the JobKeeper payment scheme coming on stream, amendments were made to most modern awards, including the award that is particularly relevant to you, the Health Professionals and Support Services Award of 2010, which inserted clauses in there that enable employees to take 2 weeks pandemic leave if they're prevented from working because of government regulations, annual leave at half pay, and associated provisions, which basically mean it's got to be agreed to by the employee and the employer in writing, and the annual leave must start before the 30th of June. And however, it really didn't go that far in my estimation because there were no broader measures adopted through the award, like the ability of employers to direct employees to take annual leave and the ability to reduce hours. So really, immediately the federal government saw that considerably more had to be done, and so brought in the coronavirus economic response package that facilitated the JobKeeper payment and the associated JobKeeper directions into the Fair Work Act. Now, moving on to there, many of you will be aware of this, but I just wanted to reiterate for everybody who's not fully across it that qualifying employers, and I'll come to what a qualifying employer is shortly, are provided with a $1,500 per fortnight per eligible employee, and I'll come to what eligible employee is, under the JobKeeper payment system, with the condition that they pay the employee at least the $1,500 for the relevant fortnight. And that goes through until the 27th of September 2020. And the basic rule is, and I don't really have time to go through the nitty-gritty of this, your accountants have probably taken you through this, that you qualify as an employer if you expect to experience a reduction in GST turnover of 30% or more in a calendar month or quarter from the 1st of April to the 30th of September, as against turnover for the same period in the previous year. Now, that on the material that I have read is a reasonable assessment and requires some sort of projection, and indications are that unless employers are behaving unreasonably in making that assessment, that the tax office is not going to have a particular problem. Now, to assist, as I said before, qualifying employers with flexibility in relation to or to complement the JobKeeper payment system, there's been changes that have been temporarily inserted into the Fair Work Act that essentially just mirror the period that at present the JobKeeper payment scheme is going to be in place. Now, I just might move the, if I can, the screen there, Jesse. Now, really, the amendments to the Fair Work Act are threefold. They enable employers to stand down employees irrespective of whether they're otherwise entitled to do so, and or to enable employers to direct employees to perform different duties or at a different location, including home. Now, there were, prior to these directions coming into place, there were issues surrounding all three of such abilities, that is, stand down, performing different duties, and the location of the performance of duties, but these have been largely clarified by the enabling directions. Additionally, despite the strict provisions in modern awards about flexibility agreements, the Fair Work Act has been amended so that employers and employees can enter into agreements that change their ordinary working hours and times, and also enable employers and employees to agree to take annual leave at half pay, irrespective of what other general laws say. And as I said earlier, the third aspect is employers can now request employees to take annual leave, which employees cannot unreasonably refuse. And I'll come back to all three of those essential features very shortly. Now, there are rules surrounding the JobKeeper payment scheme that was provided in that act that I mentioned before. Now, if the rules are not complied with, which I'll come to, there are two main consequences. If you're actually an ineligible employer and you claim JobKeeper, you're liable to repay the ATO plus penalties. And also, if you issue directions standing down employees, changing their hours of work, directing them to work from home, etc., and you're an ineligible employer under the JobKeeper payment scheme, you can be exposed to claims of breaches of the Fair Work Act, modern awards, and the contract of employment. So the short point is that the ability to do all of these things in terms of the JobKeeper directions hinges on whether in the first place the employer is eligible for the JobKeeper payment scheme in the first place. Now, the rules for eligibility in terms really focus on the eligibility for an individual employee. Now, I'll just go quickly through them. The individual employee must be an eligible employee each JobKeeper fortnight, which runs through from the 30th of March to the 27th of September. And you've probably heard that the first two fortnights are combined into the month of March and paid in arrears, and thereafter you look at it on an actual fortnightly basis. You've still got to meet that 30% projected turnover reduction at or before the end of each fortnight. So it requires continuous diligence in that regard. The third condition is that the individual is an eligible employee for each fortnight that you make the claim for them, and I'll come to what an eligible employee is. Also, the fourth condition is that you have to meet the wage condition for the eligible employee for that fortnight. The fifth one is that you have elected to participate in the scheme by notice prior to each deadline. In other words, you have to resubmit each fortnight. You have given the ATO the details for the fortnight, including those regarding the employee, and you complete record keeping requirements. Now, many of this I won't have time to go to in any detail, but you need to nonetheless to be mindful of those 7 key rules of eligibility. Now, as I said before, much of it hinges on whether an employee is eligible. Now, as I said before, also that employee must be an eligible employee for the fortnight that you make the claim for the $1,500 payment. The employee must be at least 16 years old. The employee must have been an employee no later than the 1st of March. The employee must not be a casual employee, with this exception that you can count or include long-term casual employees as being an eligible employee, provided they meet the other criteria. Now, that requires the employee to be a long-term casual employee as at the 1st of March 2020. That is, they have to be prior to the 1st of March 2020, employed on a regular and systematic basis for at least 12 months in order to be a long-term casual employee, and therefore an exception to the no casual employee rule. Even if an employee ticks the first 4 boxes that I've mentioned, they are excluded if they're on paid parental leave. Now, paid parental leave is a feature of enterprise agreements or contracts of employment. Also, non-residents are not entitled to it, or employees who are in the relevant fortnight, they're totally incapacitated for work and workers' compensation. Now, the sixth criteria of eligible employee is something that's important. An employee must choose to participate, and there are rules and around that, which I'll come to shortly. And also there's a question that you'll have if the employee has more than one job, which I will deal with right away, because if an employee has given a JobKeeper nomination to another employer, and there's a number of clients that I have, including dentists, who have employees who work for them and other employers. Dental therapists might be an example. In that situation, if the employee has given a job nomination to another employer, then it cuts them off from giving a nomination to you. They are stuck with it. So the next question is that's been asked to me is that does then employer have to nominate all eligible employees? Now, the answer to that is it's not clear, but I consider in practice the answer is yes, because what, from all I've read, the ATO intends to do is to employ an one-in, all-in rule administratively. Now, what I mean by that is it's not expressly required by either the Coronavirus Economic Response Package Payments and Benefits Act of 2020, which is the one that provides for the JobKeeper payment itself, or the rules that surround that act, which I've just gone through a number of them, that you have to nominate all eligible employees. But the explanatory memorandum to the payment rules says what I've extracted there. Once an employer decides to participate in the scheme and their eligible employees have agreed to be nominated, the employer must ensure that all eligible employees are covered by the participation in the scheme. This includes all eligible employees who are undertaking work for the employer have been stood down. The employer cannot select which eligible employees will participate in the scheme. This one-in, all-in rule is a key feature of the scheme. So if all of the criteria have been met by eligible employees and you decide to participate in the scheme, you have to nominate all eligible employees and otherwise comply with the scheme, including passing on at least a $1,500 payment to the employees. Now, I mentioned before that another key feature of the entire JobKeeper scheme is the wage condition, and that condition is that that you pay your employees, eligible employees, at least $1,500 for the fortnight. Now, it's and noting that the JobKeeper is paid in arrears, so that depends. If you're paying them other than in arrears, you pay the employee and then you collect the money from the government, and it washes out in that way. Now, as for the $1,500, it is comprised of the total amounts that are paid to the employee, or in the case of salary sacrifice payments, the value of them. It does not include super guarantee contribution that you make under the superannuation guarantee legislation, but it does include, for instance, the value of salary sacrifice into super made by the employee from their super. Now, where the payroll is other than a fortnight, and it's little help here, the Fair Work Act, by the way, enables employers to pay employees monthly. All that the legislation says is the wage condition is to be allocated to fortnights in a reasonable manner. Now, it's not clear whether, in that instance, to me, that means you can still continue to pay on a monthly basis, or whether you must pay the payment fortnightly. So watch this space, and once I finally find out what the case is there, I will let Jesse know and he can pass on that information to you. Now, the next aspect of it, you recall that there's a wage condition. There is also, not to be confused with the wage condition, there's a minimum payment guarantee. Now, that is that employees have to be paid the greater of the JobKeeper $1,500 per fortnight, or their usual remuneration for the fortnight that they would be paid for working the hours that they work in the fortnight. So if for working their hours, the employee usually earns less than $1,500, they get boosted to $1,500. And that may well be the case, for example, with casual employees or part-time employees. If the employee usually earns more than their $1,500, they still get their ordinary pay, and you get, as it were, a rebate on up to the tune of $1,500 on that. And if they work, and I'll come to this later, less hours than usual under the JobKeeper directions, they get the $1,500 or the reduced wages because of the reduced hours, whichever is the greater. And again, just with the wage condition, the minimum payment guarantee is a civil remedy provision, which means that penalties apply if you don't comply with the wage condition and the minimum payment guarantee. Now, I'll now move on. That's dealt with, Jesse and everybody, the overview of the JobKeeper payment scheme that I wanted to run through. The next aspect of things, I'm just keeping a check on the time, we're going quite well in terms of available time, goes to the JobKeeper directions, which, as I said earlier, are intended to complement the JobKeeper payment scheme and help you deal with the challenges that your business is facing and you anticipate will face until whenever it is we get out of this. Now, the amendments to the Fair Work Act enable employers to direct a full or partial stand down without pay, but subject to the minimum payment guarantee that I went through before. Now, that applies regardless of what anything else says to the contrary. Now, the key conditions, as I mentioned before, are this is not carte blanche for everybody, regardless, to do what the JobKeeper directions enable to be done. Rather, you must be a qualifying employer at the time the direction is given. In other words, you must be a qualifying employer under the JobKeeper payment rules that I outlined previously. Secondly, the reason for you directing a full or partial stand down without pay must be that of the employee not being able to be usually employed for normal hours during the stand down period because of business changes due to COVID-19, that is your personal business changes, or government initiatives to slow the pandemic. So in other words, you must be able to reasonably be able to justify the full or partial stand down without pay for COVID-19 changes that you see necessary to your business, or in order to comply with government initiatives or rules to slow down the pandemic. You can't stand down people while they're on authorised paid or unpaid leave. If they're on authorised leave at the time, they get paid what they're normally entitled to be paid for that authorised leave. and of course are on their unpaid leave, it doesn't matter because they're not getting paid anyway. The base hourly rate of pay guarantee is not diminished. In other words, for the hours that they work, whilst they're partially stood down without pay, is what they're guaranteed to be paid for those hours work. And the final condition is that it must be reasonable for you to do so, and that the stand down must be in writing, that 3 days notice is provided, and there's consultation beforehand. I might just pause there to say that consultation does not require agreement, rather simply that you consult the employee beforehand about what you propose to do, take into account anything that they say. If you do that, you can implement the full or partial stand down, provided that you comply with all the other conditions. Now, the next thing is, in addition to or separately from affecting a full or partial stand down, you can direct the employee to perform any duties that are within the employee's skill and competence, regardless of whether the contract of employment, an industrial instrument like a modern award, or any other legislation might indicate otherwise. Now, it is common in reaching my ears that people in the dentist industry are already asking me questions about this and proposing to do this by getting employees that, for instance, again, I mentioned dental therapists or the like, because they can't do their normal duties, to do administrative duties. So the question arises, can we do that? Well, provided you meet the conditions, the answer is yes, because ordinarily, because or marketing duties or anything like that, because the keys are, it's within the employee's skill and competence. Basic administrative duties, in my judgment, are going to be. And provided you meet the rest of the key conditions which are there, that simply go to qualification, safety, that you can demonstrate that you can reasonably believe that the direction's necessary to continue the employment of the employee. In other words, if you didn't give them the changing duty direction, that would lead to the termination of their employment. They still have their hourly rate of pay guarantee for doing those duties, and the same reasonableness in writing, notice and consultation requirements that I mentioned in the case of the full or partial stand down. Now, changing hours, this is different, you must understand, from the stand down direction and the changing duty direction. They have the rules around them, and it's true that through a partial stand down, employees can be required to change their working times by simply being stood down for part of their ordinary times. This is another thing that enables employers and employees to enter into an agreement that simply, this is not a direction, it's an agreement to change ordinary working hours and times, irrespective of the rules that you might find in modern awards or other legislative requirements. Now, the key conditions are there. Again, it really relates to some that go to, that are similar in the, or required in the stand down and changing of duties, directions that can be made, but must be in writing. You still need to be a qualifying employer at the time. The variation must be safe. But this is the thing, you can't reach an agreement about changing ordinary working days and times and also reduce hours. The only way you can do that is through a stand down direction. But if you're going to have or seek to enter into such an agreement, the employee can't unreasonably refuse the request that they enter into one. Next, this really is coming to towards the end of the general overview of these job keeper payment and directions and other facilities, Jesse, that I wanted to outline. You can also make an agreement with an employee that they take annual leave at half pay, irrespective of the modern award. And the key conditions are that it must be in writing. And again, you've got to be a qualifying employer at the time. There's another rule that associates the annual leave taking at half pay, is that, as I recall, is that the amount of leave that must be preserved is 2 weeks. Now, there's a question which I'm still not clear from what I've read in the legislation, but I believe that leave accrues whilst the employee is on a leave at half pay at the normal rate, which is 4 weeks per completed year of service. So that even though the leave is being taken at half pay, they still accrue the leave that they, as per normal, as they would during the time that they're on that leave without at half pay. Now, finally, there's also the facility to not only request employees to take leave at half pay by agreement, and that can't be unreasonably refused. Employers can actually request employees to take their paid annual leave, which that request can't be unreasonably refused. And there the conditions, again, it hinges on the employer being a qualifying employer and the employee being an eligible employee, and the 2 weeks unused paid leave being able to be retained. Now, I put in a bit here about long service leave, and of course, people will be all around the country, so I can't address every long service leave because long service leave is state or territory based legislation. But regardless of any of this, I make the point that in the ACT, and there are rules, similar rules around this in other states and territories, that employers can require employees to take their accrued annual long service leave, I should say, on 60 days notice. So there's also the ability, regardless of any of this, upon notice for employers to direct employees to take long service leave on notice. Now, that leads me to my general overview. I note there's around 20 minutes or more, Jesse, for questions and further
I've got a ton
comment to be made.
I've got a ton of questions for you, mate. Okay, so I've made some notes and I'll try and get through all these. Some of them are fairly similar themes, John, so we can go from there. One of the questions I had for you was as it relates to going free JobKeeper, 12 months for a small business in terms of being able to dismiss someone and not be caught up with the unfair dismissal provision. Does service under JobKeeper count as effective service for that?
Yeah.
If you're
Yeah.
thinking of terminating someone and they're on JobKeeper, can you still remove them from the business while they're on JobKeeper?
There's two issues there, Jesse. Yes, whilst employees are on or in receipt of the JobKeeper payments, in other words, JobKeeper period, they're still employed and their continuity of service keeps going. So if you're a small business employer and you have an employee who is still in the first 12 months of service, and for the benefit of people who aren't aware, employees who work for small businesses, which is anyone who employs less than 15 employees at any particular time where the termination occurs or the dismissal occurs, not including casuals other than long-term casuals of the kind that I mentioned before, are not protected from unfair dismissal unless they have completed 12 months service at the time of the dismissal. So the short and obvious point is, if you are contemplating reducing staff and you have employees who have served less than that 12 month qualifying period, it is best for you, in my judgment, to bite that bullet and terminate them because they're not protected from unfair dismissal. But bear in mind, as Jesse has just asked and I've clarified, the time that they are on JobKeeper payments is included in that 12-month period. Now, I should mention, Jesse, and this is a matter I've discussed with you and other dentists, that in addition to the unfair dismissal provisions of the Fair Work Act, the Fair Work Act has what are known as the general protections provisions, and they're quite colloquially known as the adverse action provisions. Now, what they do is prevent employers from terminating or dismissing employees. That's a form of adverse action for various prohibited reasons. They include normal reasons that you'd be familiar with, discrimination ones like age, sex, etc. They also have a rather nebulous provision that prevents employers from terminating employees because they made a complaint or inquiry in relation to their employment. Now that nebulous and broad provision is regularly availed by employees who do not have unfair dismissal rights. So therefore you need to be very careful in structuring your reasons not to come close to enabling the employee to say, I've been dismissed because I made a complaint or inquiry in relation to your employment. And so in the COVID-19 environment, you make it very clear in writing that the reason they're being dismissed is because of reasons related to affordability, business downturn, restructure of business hours, etc., caused or related to COVID-19 aspects.
Perfect.
Sorry, Jesse, it's a bit long-winded in asking that question. I know we've got a lot.
Sorry, mate. I probably was a. I'll start with something else. Now, there's a lot of questions here, Mark. From Mark. Sorry, here, John. Eligibility for the employer. Is it do they only have to satisfy the 30% downturn criteria once during the COVID period to September, or is it kind of monthly?
My understanding is that an assessment has to be made at the time you apply each fortnight. But I'm not full bottle on that, I must say, other than to understand that the tax office intends to be flexible on this and reasonable. I don't know whether, if it appears, that you in a particular quarter are not going to meet it because you've had, surprising as it may be in the dental industry, an uptick in income, whether you then are disbarred, or whether it's simply at the start of making the application, your assessment as being a qualifying employer. But I'll take that on notice and get back to you.
Okay, thanks, mate. Another question here is Frank's asking, I understand that we can nominate a beneficiary of the trust to receive JobKeeper payment who is not an employee but associated with the business. What documentation do we need to prove that association? Is that an accounting question or is that a law question?
I think that's more an accounting question.
Yeah, okay, cool. Frank, can I suggest you review the webinars we did with Adrian on that? Okay, so moving along, if an employee has been on pay without leave for the past month and you back pay them, do you have to pay super on the JobKeeper for hours that they haven't provided a service for?
No.
No. There we go. Great. All right, now, can we negotiate? Here's some, this is the question. This is the scenario I spoke to you about today. Can we negotiate pay with someone who we've made redundant and with JobKeeper would like to reinstate them? In other words, can we change their pay rate?
Yes. Now, the reason I say that is if the employee has been made redundant, their employment has ended.
Great.
Right?
Yep.
Any re-engagement of the employee, for whatever reason, is fresh employment.
Great.
Therefore, provided that for the renegotiated hours, the payment and hours worked, the payment is not less than the minimum payments that I've outlined today, you can do what you like in terms of offering wages. But if you simply offer the award wage, it's not possible to get into trouble because you are paying for the hours worked, the minimum wage that the employee is entitled to under the award. And if they work less hours, then they would be paid under the award up to $1,500. They get $1,500. If they work less hours, they get $1,500.
Cool. All right. Happy days. So if they have someone who they can't reach agreement with about the number of hours they're going to work under JobKeeper, what are the options? Do they stand them down with no pay, or can they send them on annual leave? Or what else can they do if they can't reach agreement?
Well, all of the things are available. Provided you meet the eligibility rules, you can stand them down with no pay. In that event, they'll simply get the $1,500.
Perfect. Okay. All righty.
Sorry, I haven't completely answered that question, Jesse. Another alternative is to say, well, there's no bar on terminating employees during this period for any reason. Now, it might be that alternative to standing down, that you decide that you no longer want the job at this point in time and you can't see it improving in the foreseeable future, performed by anyone or done by anyone. Now, that's the definition of redundancy. Redundancy occurs where the employer decides that it doesn't want the job that the employee's been doing done by anyone. Now, if you reach that decision and provided that you comply with the easy consultation requirements under the modern award, or if you've got one, the enterprise agreement that you've got. And you can demonstrate that there's no other reasonable alternative position that they can be employed in, that constitutes a genuine redundancy. And even if the employee is otherwise protected from unfair dismissal, in other words, they've served more than the 12 months that I spoke about earlier, it's a genuine redundancy and you're not at risk of an unsuccessful unfair dismissal claim.
Great. Cool. Alrighty. There's a whole lot of stuff coming through the chat. I'll come back to that in a second because I think there's going to be follow-up questions about that. But we can't rehire within 3 months for the same role is what they're asking. Can you rehire for the same role within 3 months?
Look, there is no hard and fast rule about that in terms of redundancy, Jesse. We're talking about redundancy here. My advice is that, yes, you can rehire within 3 months, provided that you can reasonably say, or this is the risk if you don't, that, look, we thought we didn't want the job performed by the employee done by anyone. At the time, we were wrong because things rapidly changed.
Yeah.
Now, if that's genuine, the employee is not going to be able to come back and say, well, you appointed someone to my job a month later. It shows my employment, my termination was not genuine on the grounds of redundancy.
Right.
But provided you can say, well, things rapidly changed that we weren't aware of at the time or couldn't reasonably foresee, the employee is not going to be able to demonstrate that at the time they were dismissed, their dismissal was not a genuine redundancy.
Sure. Awesome. All right. I'm going to suggest that person probably just gets some clarification around that matter as well. All righty. So I found the question I need to ask. I know I've done that one. Sorry. Where is the person's question I'm trying to find? For part-time employees, e.g. hygienists, could two employers alternate fortnights, i.e. be the job keeper per employer for one fortnight, and then the next fortnight nominate a different employer and go back and forth if the employee...
I don't think so, Jesse, because the way I read the legislation, and it's not clear, that is that if you have nominated for one employer and that employer, and you're still working for both employers, you cannot go betwixt and between. You're stuck with the initial nomination.
Yeah, cool. Alrighty, that's excellent. Hey, Jesse, I'd love to understand about JobKeeper for those on maternity leave, in particular, after they've already finished their paid parental leave, so they're just on unpaid leave. Permanent employee due to return late in the year, do they qualify for JobKeeper?
Not until they return to work.
Got it. Perfect. Thank you.
The reason for that is maternity leave is leave without pay.
Yeah, got it. Awesome. If we have a written agreement with an employee to reduce hours to the extent they can work the hours as needed and take leave without pay, and they decide to take job seeker instead of JobKeeper, do we as an employer...
I'm sorry, Jesse, I didn't hear the last phrase.
Sorry, mate, it's quite long. Okay. If we have a written agreement with an employee to reduce their hours to the extent they work as needed and take leave without pay, annual leave, or long service leave, and they decide to take job seeker instead of JobKeeper, do we as an employer have the right to offer them any hours because it makes no financial sense to do so because their wage is not... So basically, if someone's saying, we want to reduce the hours, and that employee says, I'm going to go on job seeker, I think what he's asking is, do they have an obligation to give them any hours at all, given that it's not going to be covered by JobKeeper? And I would have thought not.
No.
All right. Okay, cool. What I would like to just, there's a couple more questions here. Okay. What happens with long-term casuals? Does this change apply for their hours and days? I'm not quite sure what you're asking, Penny, but I guess the question is JobKeeper. You know, they get their $1,500 depending on the hours they pay. And if they work more hours, it takes them over the 1,500. You have to top it up. Would be
Correct.
my take on that.
Correct. Recall that I earlier said that long-term casuals, that is those who've been employed regularly and systematically for a period of 12 months, and that can be grey in many instances, even if they've been employed for 12 months, over a period of 12 months, they're eligible employees as the exception to the no casuals rule. And therefore, if all the other eligibility requirements both ways are met, then they get the 1,500 at least.
Okay, cool. Okay, I have a staff member just 3 months into employment stating that she has to take stress leave. She only has 11 hours of sick leave accumulated. She's eligible for JobKeeper. Do I pay for the unpaid sick leave using JobKeeper as well? Can JobKeeper be used to pay sick leave?
No, I don't. Just going back, JobKeeper is when you're on. Just a minute. Can I just pause that, Jesse? Because I want to make. I just want to ask if the employee said that they are on stress leave, then the first thing that the employer should do, if it hasn't done already, should notify the insurer. If they go, can you just hang on a sec? I just want to go back to. Sorry, Jess.
Yeah.
If I can't find this quickly, I'm not going to hold up things.
That's okay. I know it's a bit of a curly one.
But just a sec. I think that they are included. Employees on paid sick leave are still eligible employees.
Mm-hmm.
And therefore they get the 1,500 or more, whatever their normal pay would be when they're on sick leave.
Yeah.
Or less the 1,500, up to $1,500. But I will need to go back and check that.
Okay. There's a potential for rorting that, I guess, isn't there?
Yeah. Well, that's right. Although it's simply the rorting exists in the employee refusing to perform work and still pocketing their money. Yeah. At least until their paid sick leave credits run out.
Yeah. All right, here we go. May I ask if the employee was full-time/part-time permanent on the 1st of March, but became a true casual on or after 30th of March due to the downturn, would this new casual employee be eligible from now on since she was full-time or part-time?
Yes. Yep.
So yes. Yep. It's fine. So that answers that question. All right. But I've got a bit of a different question, something we haven't covered. If we've got people working from home, what are the workplace health and safety requirements that people need to be conscious of?
Well, I consider them to be pretty simple, at least in what I envisage people who are working from home, who are employed in dental practices are. The basic rule, as everybody knows, is that employers have to take all reasonably practical steps to ensure that the place of work is safe from illness or injury on the part of the employee. Now, if you're working from home, the authorities take a practical approach to this. They realise that ordinarily people can't conduct inspections of each and everybody's home what I do for both clients and indeed in my firm is that I provide a checklist, a working from home checklist, which identifies all reasonably foreseeable risks that I can identify in terms of working from a home. The employee is required to do their own checking of the home, and also it finishes off with a catch-all. Are there any other risks that you can see?
Right.
Now, if the employee completes that checklist and certifies that they've properly done it, I don't consider that ordinarily, that means unless you've got other information that would indicate the contrary, that the employer need do anything more.
Got it. Cool. Thank you, mate. I think that's a hot tip for a few people, because I know there's some admin team working at home or whatever. So I think there's a question here I overlooked. I apologize, Michael. Hey, Jesse, if someone is casual and has exams and they're not available until May, if we put her on JobKeeper, do we need to back pay her, or just from the time that she comes back to work?
The latter.
The latter. Got it.
Because they're not working.
Yeah. John, I'm really conscious of the time, but I do just want to ask you one or two quick questions.
No, you feel free. And Jesse, look, if there are rafts of questions either before you or that come in as a result of this, they can be sent to me, and they can either be the subject of a further, webinar within the week.
Thank you, mate.
Or I can send a note to you on them. Bear in mind, of course, everything I've said is general advice. It's not to be taken and acted upon unless there's a proper retainer with me, simply for professional rules. And because I don't know all of the detail of everyone's circumstances.
And I think everyone on here would hopefully appreciate that. What I'd like to talk about just really quickly, John, is what the world's going to look like in a post-coronavirus workforce. I don't know how good your crystal ball is. Mine's decidedly cloudy. But what I'm wanting to talk about is how, one of the things I'm thinking, John, is the coronavirus has provided an opportunity for many of us to reflect and to understand that the practice that we had before coronavirus may not be the practice we want to take forward into the future in terms of our employment structures, our staffing, blah, 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 blah. So where I'm asking this is, how do we create flexibility with our employment structures to give us the ability to maneuver our business as the operating environment, continues to change and evolve? I'd really just love it if you could speak to that for a minute.
That is a crystal ball question, Jesse, because for this reason, all of the provisions of the Fair Work Act, including the provisions to do with what modern awards have to provide for, and also the rules around the making of enterprise agreements, have been formulated without any thought in mind of what the aftermath, or for that matter, what the space within a pandemic looks like, or for employment. I anticipate that whilst I've said that these rules that I've outlined today and the job seeker payments only in place at the moment until the 28th of September this year, that in the meantime, the government, and they've already hinted at this, at looking at changes to workplace laws to provide for greater flexibility. My personal opinion is that it is going to be a long time before things recover, if ever, to the situation that existed prior to mid-March. And therefore that the system that we have of minimum conditions of employment extensively set out in modern awards, and therefore enterprise agreements have to largely meet them by reason of, as you know, of the Better Off Overall test, are simply going to have to be looked at very clearly or carefully. And you know what, John, for what it's worth, what John Howard came up with Work Choices Mark 1 may well have to be the system. Now, how do you plan for that? Because it's a crystal ball. All I can say is that I think what employers need to do at this present moment is really to look at what they really need to have at the moment, with such compassion as they might bring to bear, as they consider as appropriate. I can't lecture people in that. And look at their workforce, determine what it is going to be, implement that workforce with as much facility as is provided for by the JobKeeper directions and changes that I've outlined here, implement that and see if they can be built upon or maintained at the end of the time that the government says, look, we are going back to normal, which, as I've said, I can't see happening for quite a long time. So if your judgment at this point in time is, look, down the track, we're not going to need this person, well, then there's nothing preventing you from terminating their employment now on the ground of redundancy. And recall that if you're a small business employer, you don't have to make redundancy payments.
Yeah. And I guess just on that, John, because one of the questions I get asked all the time, and a lot of people listening to this webinar tonight will know that, you know, we have an enterprise agreement, as you will know, because you crafted it. Is there going to be enough certainty for those people contemplating going down that path to warrant the creation of one now, or is it best to let the dust settle?
I think it's best to let the dust settle and avail yourself of what is now, because the government has not changed the rules that relate to enterprise agreements.
Yeah.
And so if you are provided for by the stand down directions and the change of duties directions that you can now make, I would avail yourself of those.
Great. Okay. Thank you. Now, ladies and gents, if I've missed a question, because this is like a scrolling thing for questions, if I've missed any of someone's question that feels it hasn't been answered adequately tonight, could you please just type it into the chat box for me? Not the Q&A box, the chat box, please. That's where I'm trying to collate questions so that I'm looking in one place. So I'm just going to ask if you've got anything that we've not covered to please type that in, and so we can make sure that everyone's question is answered. And John's been very generous in saying he'll come back and do it, which is very, very kind and, oh my God, generous.
I think, Jesse, the best one would be a webinar because, I can see David's raised his hand.
Oh, okay, okay. David, could you just type into the chat box, please, mate? Hi, Jesse. What if we have two employees who do not want to assist with patients and only enough admin work for one staff? Can we terminate the contract with the other staff? Can they, if people don't want to work and there's not enough work for them to redeploy into other areas, can they get rid of them?
Yes.
Yeah, great. Thanks, Angela. Good.
And if it's a redundancy, Jesse, again, and they're small business people, there's no problem.
Great. Cool. All right. Thank you to these guys who are adding these questions for me. I apologize that I didn't see them the first time. It's just like this scrolling thing.
Well, Jesse, as I say, if you assemble them, shoot them across to me and we can do another webinar in a few days' time.
There's about two, mate. Can I quickly ask them?
Yep.
All right. I have a casual employee who only works on school holidays. She works regular intervals, but is that regular and systematic?
No.
No. Great.
No.
Yep. Okay. Okay. Can I reduce my oral health therapist? Can I pay my oral health therapist and reduce her pay while she's helping on admin jobs, provided she agrees? In other words, can I negotiate her hourly rate down?
Not under those rules that you've still got to be paid her normal rate for under her contract for the alternative duties, Jesse. This is a point I made before.
Yep.
But I keep coming back to it. There's nothing wrong with this. We cannot afford to pay you at your existing rate. Will you agree to reduce your wage? If the employee says no, well, then you just terminate their employment.
Yeah.
Whilst they may bring unfair dismissal claims, and no one wants that, or general protections to say, well, you did this because I refused to reduce my wage. The answer is, I didn't do it because you complained about me proposing to reduce your wage. I reduced your wage because I couldn't afford to pay you anymore.
Yeah. Yeah, got it.
And there's never been a bar on employer saying, I can no longer afford to pay you what I'm paying you now, I must terminate your employment.
Got it.
It frankly, when you think about it for a nanosecond, it's an absurd proposition, because the effect of it is you have to keep me on regardless as if it doesn't suit my business anymore and I can't afford it.
Yeah, totally. All right, mate, just one or two last things. Definition of small business, 15 employees, correct?
Yep. Yeah, less than 15. Not including casuals, but including those long-term casuals that I mentioned before.
Okay, cool.
Now, I must say, Jesse, it is a grey area in many cases as to whether an employee is a long-term casual employee, even if it appears that they have been fairly regular and systematically employed for 12 months.
Yeah.
It is not necessarily in every case that they are.
Yeah. Okay. Look, guys, I'm going to ask one more question. The questions keep coming. I think we're going to have to call it a night in a minute. So one last question, and then I think we'll come back for round two, if that's okay with you, John.
Sure.
To get on with the evening. Okay. So what if someone during their ordinary course of employment is paid less than $1,500? And the JobKeeper payment is $1,500. Can you ask them to work extra hours at their normal rate of pay to get up to $1,500?
No, not under the rules that I've outlined tonight. I have addressed that question as recently as today, but they don't. The JobKeeper rules and directions do not permit that.
Okay.
They don't permit an employer to unilaterally increase their hours.
Got it. Okay. I know David's had his hand up for a little while, but he hasn't typed a question. So David, if you can quickly type your question in, and then that's it. We're going to call it. So David, if you want to do that, mate, we did see your hand up, so I want to acknowledge that. You've been patient. We've tried to get to as many of these questions as we can, guys. And what I've tried to do is group them into themes, because there's quite a lot of individual questions around parental leave and bloody, 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 blah. And so, you know, we've tried to answer that as succinctly as we can. Just while I'm not sure if David just said sorry, so I don't know if that means you've got a question, mate, or not. And if you do, great, type it in. If you don't, just write no question. That's cool. John, just on a personal note, I really want to say thank you so much to you for taking the time out of your day to come and share this information. It's really, really valuable. You know, for the audience listening, John is regarded as the premier employment law specialist in the ACT in New South Wales. He's the guy that the lawyers go to get their stuff taken care of. And so I'm really grateful to you, mate, for giving up an hour or so of your time tonight and offering to come back for round two. It's incredibly generous. I'm on a personal note, I'm thankful for all the advice you've given me over such a long period of time and kept me, you know, on the employment law straight and narrow. So, so thank you, mate.
I'm welcome. You're most welcome, Jesse, and everybody else. To state the bleeding obvious, these are straitened times, and you know, it's the least I could do.
Yeah, no worries. Thank you, mate. You're a good man. All right, ladies and gents, when we have round two ready to go, we will absolutely let you know when that'll be. But in the meantime, once again, John, you're an absolute champ, and looking forward to catching up with you shortly, mate, when you get back to the national capital.
Well, for those of you who've been at Lennox Head, you'll realise that is...
That's not an appealing proposition, is it?
Yeah.
Might be a new branch office up there, mate.
Yeah.
All
Good
right.
day.
Thanks, mate.
See you. Thank you,
Good
Jesse.
night,
Thanks,
everyone.
everybody.
Thanks. Bye-bye. Bye. Bye.